Great. We have Janneke. Hi, everybody. Welcome to this panel on impact assessments, and specifically trying to dive into, what is an algorithmic impact assessment, and what is their purpose, what's the difference between that and a few other things. And so I hope that you'll enjoy this panel, and definitely feel free to ask questions throughout, but we'll also reserve some time in the end specifically. I'm Ben Winters. I'm senior counsel at the Electronic Privacy Information Center. We're a US-based nonprofit focused on the preservation and promotion of privacy and civil liberties, and I lead our project on AI and human rights. And I'm thrilled to be joined by an expert panel today. So I'll introduce them very briefly. I think everyone knows them, and you can always look them up in the panel, so we'll get right into it. So farthest away from me is Calli Schroeder. She is Senior Counsel and Global Privacy Counsel for an organization you haven't heard about yet, the Electronic Privacy Information Center. She's my colleague, but has a history in compliance and has a lot of experience in the global applications of these systems, of the impact assessments. Further in is Gemma Galdon Clavell. She is the founder and CEO of ETICAS Consulting. Gemma's organization performs external audits of algorithmic systems, and she has created the Algorithmic Audit Framework, which serves as foundations for all of the audits that the organization performs. And I think we'll probably get a little bit more into detail of that later. And right next to me is Charles Helleputte. Charles is a partner at Squire, Patton, Boggs, a law firm, and he's focused here in Brussels, and he leads their EU data privacy, cybersecurity, and digital assets practice. And last but not least, up on the screen is Janneke Gerards. Janneke is a professor of fundamental rights law at Utrecht University, and she was actually one of the authors of the Fundamental Rights and Algorithmic Impact Assessment in the Netherlands. So she has a lot of firsthand experience. Before we dive in, I want to give a brief intro about why we wanted to do this panel. So impact assessments are becoming a popular answer to the growing and obvious problems of a lack of algorithmic transparency and accountability. Yet they remain inconsistently defined and definitely inconsistently enforced. It's required for some entities in US states, Colorado and California. It's required for public sector folks in Canada. Assessments come up in different ways in the GDPR, in the DSA, in Australia, Brazil, India, South Africa, and I'm sure I'm missing a few. But that is all to say that they're all coming up, and we have this moment right now where we can make sure that they are meaningful and discuss that and discuss how, what role they can play. So, in that spirit, I think I want to start out with getting a little bit of the elephant in the room of audits versus impact assessments. I use those sort of interchangeably in the introduction. And on one hand, I think audits are considered more technical, whereas impact assessments are more focused on the results, the socio-technical process. But we've often seen it used interchangeably. Often, from my perspective, I end up not really caring what they're called, just the mechanism for what they're achieving. But I'd love to start with Gemma, because I know that you use the term audits a lot in your work, but a lot of the socio-technical stuff that you measure is a lot of the same things that impact assessments aim to gather.
Yeah, so at ETICAS, we always try to be useful and to do things that people understand. And for me, words are ways to communicate. So I'm not so hung up on definitions, but as to what people understand when we say something. And we found that audits communicates a lot better what it is that we do. Audits for us are inspection mechanisms that allow us to see how a system works. An audit requires quite a lot of technical knowledge, but also technical access to a system. And in our experience, impact assessments are often developed by legal departments with no insight into the technical teams. So after trying to push for impact assessments for a long time, we just realized there was something fundamentally flawed with the idea of an impact assessment. There's no way that a technical person will think that they're responsible for an impact assessment. But if you tell them you're going to be audited, they understand what that means. So as a way to ensure that these exercises in risk assessment were taken away, in a way, from legal departments and understood as more of a technical inspection mechanism, we thought that audit communicated better. And so for the last 6 years, we've been auditing systems both as a second-party entities. That's when we are hired by an organization that develops or implements algorithms to audit their systems, and also as a third party when we collaborate with civil society to reverse engineer systems without the agreement or the compliance or even the happiness of those that are audited. So for me, it's about communicating, and it's also about making sure that what we say fits into the process of developing tech. And I think that an audit does that way more than an impact assessment.
Yeah, and Charles, as a member of those legal departments and the legal representative there with these companies, what are your thoughts on that, on the sort of wording and matter?
Yeah, and for once, I completely agree, so that's good. Yeah, I think, to your point, why I agree, I think language matters. And when we use audit, we use a term that we probably all know, but that refers to methodology. So it's really checking a certain number of things based on terms of reference and make sure that they are applied consistently across organizations, sectors, et cetera, et cetera. They have a benefit, for sure. They are different than impact assessment, and simply because the objective is different as well. So I don't think we should trade one versus the other. The good thing, to some extent, but we'll discuss that later on, is that in the EU context, most of the time, none of them are so much prescribed for now. That will change probably. But I think both have a value and have a benefit.
Thanks. Janneke, in your experience of helping to develop specifically an impact assessment, and correct me if I'm wrong, for public sector use primarily in the Netherlands, can you talk about how you went about the experience of deciding sort of what goes into that as a fundamental rights impact assessment, and whether that has substantial diversions from what we've come to think of with data protection impact assessments or algorithmic impact assessments? And I don't mean to harp on the language, but I do mean that I think the main reason I'm coming up with it a lot is because these words are used in regulatory proposals all over right now, and so it really matters what is being confirmed. So yeah, Janneke, please.
Yeah, I think for us it was really important to have a kind of ex ante system. So the point with audits, I think, is that, well, they might sound nice, but it's also something that can only take place once an algorithm is already designed and in use. And what we try to do is to actually have some kind of an ex ante mechanism to make sure that those who are, considering to perhaps start using or start developing an algorithm in a government agency should do so with very strong awareness of the consequences of that, and should be very much aware of all kinds of public interest and public value elements when making relevant decisions in that regard. So that's actually why we opted for an impact assessment rather than an auditing mechanism. And I think, what we also try to do is, many of these ex ante mechanisms, such as data protection impact assessments, are really very much focused on data protection, which is a very narrow focus in a way. There's still a lot of things that can be dealt with and can be just brought into such an impact assessment. But still, there's much more than that. There's also considerations of non-discrimination. There's considerations perhaps relating to sustainability or to other public values, as well as good governance and good administration considerations, which are all things that we think that government agencies should be aware of when making these decisions. So it's not a narrow kind of thing to do. So that's why we actually went for this more broadly oriented fundamental rights algorithmic impact assessment, rather than one that is actually focused on one very specific issue. And that also allows for it to function as a kind of coordinating instrument. It brings together a lot of the different guidelines and instruments and impact assessments that are already out there, and can make those part of the impact assessment that we have designed. And I think that makes it very suitable. And there's final point also responding to this point on, lawyers versus technical experts. So what we try to do is to make this into a kind of group exercise in a way. So we really want to have in this very, preliminary stage, a group of people to be brought together, ranging from data scientists to computer experts to lawyers to people really well versed in the topic that the algorithm should be about, to sit together and to discuss this together, to bring in all their different perspectives and ideas on this particular topic. And so far it's our impression that works well.
Great, thank you. So pulling on some of the threads that Janneke just brought up, the fact that it can be about more than just data protection, but including sustainability, fundamental rights, et cetera. Calli, I know this is sort of a big question, but what do you think an ideal picture of what an algorithmic impact assessment can achieve? And do you think that that's different when used in the public sector versus mandated in the private sector?
Yeah, that is a really big question. I think ideally audits, impact assessments, all of it, ideally they end up being tools that can be used by enforcement bodies, that can be used by the public, that can be used by the companies themselves to show that there's care and there's thought and there's intention behind what they've done. And the systems they've put together, how they're collecting information, how they're using information. The exercise that we would do when we were doing audits or impact assessments with clients, back when I did client work, the purpose really was to force those companies to think through each of the steps, to think through what they're doing, because it's very easy for companies to get so caught up in the end result of what they're doing that they don't think about the process and they don't think about the ways that this could harm them or individuals. And this is all an exercise to force them to think about it. I think ideally that should always be what the system is, and it should cover the major harms that could come up. It should cover the major risks. So it should cover, discrimination. It should hopefully cover environmental impacts. It should cover impacts on the communities that are around. It should cover how it impacts the space that company operates in. If it's an ad tech company, how is what they're doing going to affect the ad tech ecosystem as a whole, and what will be the larger impacts there? Unfortunately, it's a really big answer to all that we would like impact assessments to do. I'm not totally certain they can do everything, but I think the fact that we're all having this conversation, the fact that we've looked at this as a useful tool, and the fact that it's being incorporated into so many regulations worldwide shows that there's hope, at least, that this can be a useful system in many ways. And I'd like to hear what my two colleagues think of that as they're implementing that on a practical level.
Can I get back to?
Please.
Calli? I think you said something, a word that's really interesting, is that it forces them to think. In our experience, you cannot force organizations to think, but you can force them to comply. Thinking is not part of the job description. And in our experience, you can find one person who thinks, but it's just one person. The organization doesn't think. So we feel that impact assessments are asking organizations to do things that they're not comfortable with doing. Mm-hmm. And so you're trying to change too many things at the same time. And the same with the ex ante or ex post. It's like, let's look at reality. One of the good things, I think, one of the privileges that I have at ETICAS is that we've been working a lot with policymakers, a lot with civil society, and a lot with the industry. And I think that audits allow us to, I often say, it's like a silver bullet to the heart of the system, because every time we audit something, we have an effect, a domino effect on the incentives of the whole industry. Mm-hmm. So right now, we just got a huge contract with a large pharmaceutical company to audit all the algorithms that they outsource from third parties. Once we're done with this work, the impact that this is gonna have on the vendors of AI to the medical and pharmaceutical field are gonna be amazing. So, we weren't thinking about the process, we weren't thinking about thinking. It's like, how can we create, and in this case, it was like, pharmaceutical sector, you have a problem. You are buying AI from the outside, from other providers, and you have no idea what they're putting into your systems. And you're the ones who have the liability. So you better protect yourselves. And that really flies. And so now we have this amazing use case. For the first time, we're going to be auditing dozens of algorithms at the same time, but at the same time changing the whole incentive of the industry in the medical field. And we want to reproduce that in all the other verticals. So I think in our experience, audits work to do that, to actually change things. Impact assessments always stay at the narrative, do well, be nice, think space. That unfortunately, because of the complexities of large organizations, it doesn't seem to work as effectively as the auditing language and methodologies. But again, I don't think they're mutually exclusive. Like if you can get the public sector to do impact assessments ex ante, if you can get legal departments to ensure that someone is looking at risks more systemically, that is great. But if you can't have everything, I would say at least let's have the audit, because it does allow us to change things as they happen, but also send the message to the beginning of the pipe, to those that are developing those systems, that unless you do it well, you will not have a client.
Yeah, thank you. So a little bit on that topic about what they're actually going to be achieving and what is required. Charles, I wanna ask you, so what are requirements for your clients and for other companies in the EU, and to the extent that outside of it that you work, do you have to comply with, and what gaps exist? And given those gaps in the sort of like considerations of compliance, what sort of practices are filling that gap now, if any? And if you think that there is a hole that regulation should fill.
Yeah, so that's also a pretty big question. But I haven't done a kind of exhaustive mapping of all of the algorithm impact assessment rules that could exist. But nevertheless, I think what is important and key, and echoing what you were saying, is we should know why we are doing this. Either we do it because a regulation mandates us to do it, and that's an objective in itself. That's probably that probably means that the regulation came at the right time to solve an issue that was identified, because that's most often how regulations are done, so to try to solve problems that happen in first instance. We don't have so much of them right now, certainly on the EU side. So if you look at the initial AI Act proposal, you don't have a lot on algorithm impact assessment or very thorough and overarching thinking process, to your point, looking at a lot of the important things that could be looked into when an algorithm is deployed. Of course, that's not a position of Parliament, but in the initial AI proposal, you only had a data protection impact assessment mandatory if you were in a high-risk scenario. My take there has always been, and I know that it's probably a bit controversial, but I'll say it anyway, it's up to politicians, basically, to find what uses are so bad that they shouldn't be there. So there are cases where we shouldn't have an impact assessment whatsoever. We shouldn't just have the technology deployed. Yeah. And don't ask me to have a list of examples, but clearly I think that's a major responsibility. It's identifying those use cases that are so bad that they shouldn't be there. We know that the AI Act is doing that in a way, but if we identified human rights issue in high-risk uses of AI, I think we better prohibit those uses than trying to have documentation set up to try to demonstrate why we don't have an issue with fundamental rights with the algorithm. So that's one. Then impact assessment have been developed for a long time, even outside of algorithm. So it's something that people tends to do and to do quite often, either because they are mandated, as I mentioned, or simply because they believe that it makes them good citizens. So you have impact assessment as part of ESG, of AI ethics, part of privacy as well. So in ADM cases, you have a lot of court cases even on impact assessment, and so yeah, we have all of those kind of existing guidelines, terms of reference, and pieces that are out there. Reality is that for clients, it's pretty hard to comply and know what they actually should do. And I believe that for now at least, trying to indeed think, it's not bad, and behave as a good citizen is something that is important. And because we all know, for example, out of a privacy breach are harming data subject, but they are harming brands as well. And so I think being a good citizen and using those impact assessment as a tool for accountability is something that my take is that that's what where you make the most out of it, let's say.
Great, thank you. And Janneke, sort of on the flip side, what kind of assessments and obligations do government users in a few different countries have as of now, if any? And can you walk us through a little bit more? I know you started to in your first answer, but the results of the process of creating the fundamental rights and algorithmic impact assessments, for public use, and sort of what different models were you using throughout that process, if there was any major guiding principles, and did you have a consultation with agencies? Because I know a lot of times agencies are very hesitant, at least in the States, to agree to this sort of framework where they have to proactively do anything. But at the same time, they're using taxpayer dollars to buy algorithms, often in third party. So would love to hear a little bit more about your process there.
Well, yeah, thank you for that question, because it also allows me to respond a little bit to the previous comments that have been made. And I think our experiences really are a little bit different. Maybe that's the culture in Europe, or the fact that it's not being used. The algorithmic impact assessment that we have designed is being used by government agencies, not by the commercial industry. So that might make a difference. But in our experience, it really is true that many civil servants are actually, a little bit insecure about what they can do, and whether they can buy an algorithm and just start using it, or whether they have to design it themselves, and what kind of factors they have to take into account. And in a way, it is, starting using an algorithm is rather the same thing as starting using a new kind of policy instrument of any kind. So you will have to carefully consider that, and you have to think about it, and you have to discuss it together. So our impact assessment was designed from the fact that you use a policy tool, and you will have to carefully make decisions about that. But you will also be eventually be able to be held accountable for the choices that you've been making. So we have tried to design a kind of instrument that serves both sides. So it allows for, being a good citizen and thinking and reflecting and deliberating together. But it also requires you to write down the answers to all the nasty questions that are being asked in the impact assessments. And eventually, those can be presented to, any kind of body that will hold you accountable. So whether that's an auditing body, or whether that's a court, or just, higher management, they will be able to see the answers that you gave to the questions about, what kind of algorithm you are using, and what kind of transparency mechanisms you take, what kind of future plans you have for adapting the algorithm when it changes in the process. So all that kind of thing can be also used for accountability elements. So it's really trying to combine the best of both worlds, so allowing for audits afterwards as well as for deliberation beforehand. What we also did is extensively test this. Of course, I'm not with you there in Brussels, but I know that in the audience, Iris Muis, which is one of the co-authors of the impact assessment, is there. And perhaps she can explain even a bit more at a later point. But she has done extensive testing of this instrument with many government agencies. And of course, we first worked with volunteering, a number of organizations who were willing to cooperate. And they helped us improve the mechanism, so to pinpoint which questions were not really clear or whether it was too burdensome to have the process in a certain way, and we made changes accordingly. And we are now in the process of also training a lot of people within the government. And what we see is that on a voluntary basis, a lot of civil servants all over the government, so whether it's, more or less independent agencies or just ministries, all come to the courses, the training courses, because they want to know more about these impact assessments, because they know they will have to apply it in the end. So there is, on the one hand, the incentive of, trying to be a good civil servant and making good choices and being able to provide some kind of a motivation for what you're actually doing. And on the other hand, there is the stick, I think, of there being some kind of accountability mechanism behind all this. And there being a kind of more or less a threat of having to complete this impact assessment as an obligatory part of, starting to use an algorithm. Which is what the government is currently considering to do. And I think that in combination makes this rather successful. And we haven't so far encountered many civil servants or organizations that are actually really unwilling to go through all these processes, which was surprising for us too, but which I think is also quite promising, and I hope the same would be true in other countries as well.
I'm glad to hear that you had that experience, and thank you for explaining that. So I think one element that's coming up a lot is that the value of these audits and impact assessments can be easily sort of undermined. But one big part of it, and we've seen it with a lot of high-profile examples, is the extent to which you have access to the underlying data, the underlying sort of processes within an organization that's using an algorithm to actually meaningfully evaluate it. And so Gemma, as someone that does external audits and have also done audits with consent and access and whatnot, can you sort of talk about the different experience of doing that, and sort of what you do when you're doing an external audit, and how you can feel confident in publishing and making assessments about how it works, and whether you think it is a substantial difference in the quality of the output and how it can be used if it's done sort of with that voluntary cooperation.
Sure. So we started doing second-party audits like 6 years ago and third-party audits with civil society a couple of years ago. And one of the first things that we noticed is that the conversation in civil society and in the digital rights community, between the digital rights community and the industry, was often broken because civil society kept insisting on, we want to see the code. And companies were like, there's no way I'm going to share the code, and I have legal protection to not share the code with you. And we're like, hang on. Even when we do second-party audits, we don't need the code. Actually, if you give me the code, I can't audit you. I need to see the code as it works. Like, if you just give me a static code, I cannot do anything with it. So why are you civil society insisting on something that it's not useful, even when you have internal access to a system? So we thought, well, let's work with civil society and see with them what the possibilities of an external approach would be, an adversarial approach would be. And we're super happy to report we've done like 5 adversarial audits up until today. Some of them are going to be published in the next few weeks. And I'm very happy to report that there's no black box. Even without the agreement of the developing party, you can audit a system. And I think there's a fundamental misunderstanding when we talk about auditing or understanding how systems work. The regulator and society are not concerned about how something works, but how something impacts on society. And that's a huge difference. I don't need to map your neural network in order to ensure that you're doing things well. I need to know how your neural network is impacting on people. And think about this. There's a great example in the medical field. If you develop a medicine for a headache, and then developers realize that it's also good for Alzheimer, the regulator is going to ask you to explain why it works for Alzheimer. It's going to ask you to prove that it works for Alzheimer. We have lots of medicines out there and vaccines that we don't know why they work, but they work. And the regulator validates that they work in terms of doing what they're supposed to do. So that changes massively the scope of what do you want to do when you audit. And takes us away from these discourses of, this is unauditable, there's nothing we can do, it's more intelligent than us, we should give up and just accept the reality of data and artificial intelligence just doing away with humanity, because it's really not like that. So with civil society, we've managed to reverse engineer every single system that we've come across. The difference, though, between the third-party audit and the second-party audit is that in third-party audits, we can only have hypotheses. Because we have not had access to the data, we have not been able to validate whether what we've seen is actually what is happening. We have robust evidence. So for instance, when we audited Uber, Cabify, and Bolt in Europe for competition infringements, because in dynamic pricing, prices go up and down at the same time, we can say that we've seen that with the data that we have, but we haven't seen all of the data. But that's good enough for taxi drivers to be using that as their proof in their legal, the court challenge of the business model of these organizations. So again, it kind of shifts the burden of the proof. You have something that is good enough to tell them, now you need to prove that you're not actually doing that. So it's a really good resource for civil society. Also in the process of auditing, the awareness that we bring to civil society and the tools that we develop together with these groups, we often hire civil society representatives to do part of the field work. So the idea is that in the future, they will not need us to do this. And in the next couple of weeks, hopefully in early June, we're going to be publishing our third-party auditing guide to help civil society organizations make better and quicker decisions on how to audit these systems. There's lots of different methodologies that you can use, some more technical, some less technical. We do scraping, we do sock puppeting, but we also do interviews, we do data analysis. So just kind of understanding what is the data that you have available from a system that is impacting you or your communities, and what kind of methodologies do you have at hand, and what kind of profiles do you need to do those audits. So main ideas, you don't need code. Third-party access is incredibly promising, even if you only get a strong hypothesis and not actual proof of what may be happening inside the algorithm.
And can you briefly, I know it's sort of like 19 elements, but I know you have a sort of framework of your audits that touch on specific points. And just so for the benefit of the audience, can you hit on some of what those points are so we have a better picture of what the ecosystem you're gathering is?
Totally. So the Bible that we use internally is a methodology that follows the AI life cycle. So there's two ideas that are very important to communicate, and that's the agreement that came out of the first meeting of algorithmic auditors that took place in Brussels last November. Audits must be end-to-end. That means it's not only about the model, but it's about the AI system or process. So a model audit will never be a valid audit, and actually the results of a model audit will almost always be misleading. So they need to be end-to-end, and they need to be socio-technical. Because when you get out of the model, the decisions are not just technical. So in our methodology, we audit pre-processing, in-processing, and post-processing. That's end-to-end. Post-processing is not always relevant. Post-processing is only relevant when there's a human in the loop and when there's someone that manages an algorithmic decision, like in a bank, when a system decides whether you should get a mortgage or not, but that decision is being managed by a bank employee. So that's when we do post-processing. In other kinds of system, it's only pre-processing and post-processing. And in this AI lifecycle, we've mapped 19 moments of bias and inefficiency. And it's important to highlight the inefficiency. Auditing for bias allows us to see so many things. We audit for bias and inefficiency while validating compliance with privacy, data protection, labor law, competition law. So it's such a rich resource in terms of looking at the inside of a system. In these 19 moments of bias, just for you to get an idea, the first one is techno-solutionist bias. which is our way of landing the principles of proportionality and data minimization. Are there alternatives that are no-tech or low-tech that you could use to do the same thing? And then if there are, your whole system is flawed from the very beginning. And not just because we say so, but because there's a regulation that forces you to prove that you're complying with the proportionality and the data minimization principle. So basically, an audit is like the last mile of enforcement and compliance. You have all these principles, you have laws, you have standards, but in AI, impact is contextual. Auditing a mental health system in Pennsylvania, as we've done, is very different from auditing a natural language processing used by a major EU city. The dynamics of discrimination and the problems that may encounter and the organizational settings are completely different. So something needs to bridge this last mile that ensures that all these principles, laws, and standards are translated into your specific use case. Auditing is a dynamic piece that allows us to do that, taking into account everything that is mentioned in all those references that we must have, that we've landed in those 19 moments of bias, and by verifying those 19 moments of bias, we ensure compliance with all the fixed elements of the regulation. So that's basically how we do it. That's what we look at. The process is a bit different. The first interaction with the client is that we share a model card with them. They give us the information that they have, and with that, we start checking for the moments of bias. And we've been using this methodology for quite a long time, and it works. Our concern with the DSA is, would this work with social media platforms? And I'm very happy to report that it does. What we are doing is we've identified 4 algorithmic processes that are key in social media platforms, and so we use our methodology, the 19 moments of bias, in 4 crucial processes in social media. In content recommendation, and we check for misinformation, rabbit holes, polarization, mental health issues, and stereotyping, the things that have been identified in the literature as relevant. The second process that we audit is ad personalization, whether there's anything that may be pointing to bias or inefficiency, or something that is socially unacceptable in those dynamics. The third one is image cropping. So you may remember that was the problem that Twitter had a couple of years ago. When Twitter would crop the images, it would tend to select the faces of white men. So image cropping and image selection is also a process where we've already identified that there's risk of non-compliance. And finally, social graph recommendation. So what kind of friends are being recommended to you. As we develop this, and we're in conversations with social media platforms to audit them before September for the DSA, we may find others, but I'm very happy to say that in the same way that we've adapted this kind of overarching methodology to social media, I think we can find ways for this kind of socio-technical end-to-end understanding of how to inspect an AI system to be useful in lots of different domains. So I think we're onto something really powerful and promising that can be accepted by the regulator, but also by the industry as an inspection mechanism that works.
Thanks, and I promise the very big questions are over, and I'll try to be a little bit more precise now. But so starting with Calli, and I also like Charles' perspective on this. What segments of an impact assessment or an audit should be made public, and how does this change based on what party is using it or developing it, whether that be a government, large company, small company, nonprofit, and sort of that gets a little bit to the transparency and accountability aims you touched on at the beginning. How should that be made public, and what's the value of that, and what specific parts should be kept?
Yeah, that's a really good question, partly because what I learned in client work is that any possible thing that a client can say is a trade secret or a company secret, they will use to try and keep everything under wraps. So from my standpoint, working as a privacy advocate for Epic, I want as much as humanly possible to be public in an impact assessment. I think more transparency is good. I think that it's better for people and better for enforcement bodies if you can really see how in depth that company has engaged with the audit or the impact assessment, and how they're looking at their own systems and what they know about how everything is processed. I don't think it's very likely that we're going to have fully transparent or fully public audits. So in general, I would say the things that absolutely have to be made public, you have to make what the questions are public. You have to show people what the framework of that impact assessment and audit is. So you have to know what is it that the company or the outside assessor is looking at. What are the questions they ask? How deep do they go? Look at make public what departments are involved in that discussion. It's really important to know if the technologists at a company have actually engaged with an assessment, or if it has all been, the marketing team or publicists or lawyers or anyone else. You want it to go through the whole organization, because different departments know very different things about how everything functions. When I was doing compliance work, one of the things that we would frequently do to avoid the problem of, well, how much of the information that we pulled when we were making this assessment are we allowed to make public, was we would have one version that had all of that information that was kept internal for the company and for showing to regulators if it was requested by regulators. And then you would have essentially a report card at the end that had what all the questions were, what all the sections were, and essentially whether the company passed on compliance there, had some things they needed to fix, or had failed in that section. And that was something that they could share with third parties, and they could share with their clients, and that could be made totally public safely. So that's one approach you can make when you're looking at what to make public. But I think there's absolutely no way to avoid that. The questions and the methodology has to be something that you share.
Yeah, and of course the question is, share with whom for what? So I think it also depends on the approach we want to take. So if the idea is to have a kind of product safety approach, then it's only natural that the end user get to know in a kind of very synthetic way what's going on, what are the risks, almost like your dryer of with codes and colors. So, but we should all realize that the objective are fundamentally different. So if what you want to give is give the end user a sense of what's the risk for him or for her, you will lead into one direction. If you want to give a potential enforcer a good trail of what was done and why something is done in a certain way, you probably you will likely have a better result if that assessment will be made available to the regulator, but not all of the trade-off, etc., are not made public like very widely. So I think that's something where the balancing is probably complicated, but that's what makes life interesting. One thing that I'll just flag on the DSA, and that is really in the same vein, you all have heard that the EU has set up a center for algorithmic transparency. That's probably good. So it's a research center that aims to work on what it means to have transparency in algorithm. The worrying part, at least for industry, is that the EU Commission is pretty clear that they will use that resource both for research but also for enforcement. So they are contemplating to share data between themselves, feed the center with data that they are having when they are doing investigation, taking the intelligence to do further investigation. I think there is some conflict there that probably should be flagged. So.
Thanks. And Janneke, I'd love for you to start with this one. But in structuring an assessment, what kind of balance do you strive to have between giving precise language of what questions have to be answered versus sort of like broader categorical systems that you wanna hit, right? So I'd be curious to see what your perspective is on striking that balance between precision and not sort of overly technical to the point where you're obscuring what's happening in regards to real impact.
So, well, technical for the persons who will have to make use of the impact assessments, or
to perform the assessment, to fill it out.
Okay. Yeah. Well, we have actually tried two different approaches to solve that problem, and I think the first one I already mentioned, which is that we ask a team to complete the assessment, which is an interdisciplinary, or if you like, a multidisciplinary team probably on the one hand, the data scientist or the computer scientist might not really be very well versed in the very strong legal jargon that we use. So they might find it difficult to deal with very specific fundamental rights issues or proportionality issues. And the other way around for, well, the average lawyer, it will be completely incomprehensible how these algorithms really function. But if you put them together and somehow incentivize them to try to explain to each other what is actually meant and what can be done, that proves to work relatively well. So that's a first kind of approach. And for some questions, so if you are dealing with questions related to the kind of data set you want to use, or the degree of transparency you would like to offer, probably the lawyer can't play that much of a role, but then it's mainly the data scientist who will, for instance, take the lead and try to explain to the project leader what can happen. So it's a little bit diverse who will take the lead in answering some of the impact assessment questions. So that's the first approach. The other one is that we have formulated relatively general questions, but we have also included for each question quite an extensive, explanatory memorandum, if you like. So we have explained what we mean with each question. And there we have sometimes used rather technical language, but we also try to explain in, layman's language what those terms mean. And we have included many references to other existing instruments, whether it's the EU's ethical guidelines or national guidelines on bias and different types of bias that can creep into algorithms, or mitigating measures. Well, you can have a whole range of different tools that could be interesting. And we then asked the person who's in charge in answering a certain question to actually also study the explanations and make use of the tools that we refer to in coming up with a kind of tentative answer to the question. And in that way, we try to bridge the gap between the different levels of knowledge and expertise that the different involved persons have, and try to bring all that together. And as mentioned, I think that works quite well, but it always, that's true for all kinds of, we know that from our own work and research as well. It's much easier to talk to your peers who have the same kind of background and who use the same kind of language as you do. But it's much more difficult to sit together with people who don't. But still, if you actually dedicate a bit of time to that, then it can be achieved, I think.
And in a context, in a jurisdiction that is sort of putting effort towards some sort of public sector algorithmic accountability, like for example in the Netherlands and Amsterdam, they've endeavored to have a sort of algorithms registry. How do you see the requirement or availability of the fundamental rights impact assessment sort of interacting with that like baseline transparency about what systems are being used?
Yeah, that's a very interesting kind of development. It's a little bit, it is related to the impact assessments, but of course it's not a necessary kind of relationship. But what we can see is that some municipalities, and currently also the central government, is developing these registers, and so they contain information about which algorithms are used to make or support specific decisions or specific regulations. And they also provide a little bit of information that can be understandable to the general public about them. So that's a kind of open communication, transparency, explainability kind of thing. But what we can see is that increasingly these mechanisms also, so these registers also contain some information that can be useful to audits in the end. So well, the instrument that I know best is the central government's experimental pilots in these matters. And what they have included is, well, a number of bits of information about how the algorithm came into being and whether, for instance, the FRIA, so Development Rights Impact Assessment for Algorithms, has been actually used, and whether it has been found that it's going to be a proportionate instrument, and whether it meets all the kind of standards that we have entered in that impact assessment. And I think that's, well, to a certain extent, that works really nicely because, well, you can also see as an outsider that in some cases the FRIA has not been completed. And then, well, that might start ringing a bell, and perhaps we should do something about that. When it has been completed, well, of course, it depends, and that turns back to the transparency and openness issue, how much information that has been entered in the response boxes for all of these questions will actually be public and will be openly available to people to read. But you can use such a register also to provide that kind of information and to make it, well, to really provide for open governance and transparent governance to the wider public. And I think that can be really valuable. Of course, then you should try to avoid overly technical language, but I think that will be obvious, and try to explain this in less technical terms. But I think, as Gemma really well explained, that really can be done. It's not, I mean, it's not that easy, but it's also not impossible.
Thanks. Yeah, absolutely.
So just reacting to that, sometimes you don't even need a regulation to put that in place. So if because existing regulation will already mandate to some extent public authorities to do so. So there is a case in the Slovak Republic where the Slovak Constitutional Court mandated the tax authorities to be much more transparent about its use of algorithm to select a taxpayer it will be auditing. And so that exists and was considered under accountability and transparency principle without the need to have specific legislation in place. So,
yeah, and Charles, I'm curious if you can talk a little bit about in the commercial context. So Janneke talked a little bit about the parties that are actually completing assessments and considering it. And so in your work, what are some of the different models that you see and try to encourage, whether it's mostly like you and the law firm's team, or you like mandated, requiring others at the companies to do it, and yeah.
Yeah, so there I'll pretty much echo what Janneke was saying already. I think if we want those assessments to be successful, we need to be wide encompassing. We saw in other fields way too often when having to do DPIAs, for example, that the DPIA burden is just outsourced to the firm because they, let's say, organization know it's a necessary burden, but they don't want to invest the time to help us to do a meaningful DPIA. Mm-hmm. That's probably not exactly the right outcome. I even had a client ask me to do a DPIA on an illegal processing activity. So yeah, I didn't do it, of course. So I think if you want to be successful, you need really to be wide encompassing. For privacy professionals like I am, I think we should also be very modest and realize that that matter is way beyond privacy. Mm-hmm. That risk at stake are very different than the one we know. And so, of course, we need a lot of different resources if we want to do that right. So it's certainly us as outside counsel, then the client itself, but not just the privacy department. We need to get access to the technical expert, and if they don't have those experts, that's probably a bit worrying. But if experts don't want to invest, we should outsource that as well to make sure that the outcome is right.
Thanks. So if anybody has questions that they'd like to ask the panelists, you can line up at the microphone. I'm going to ask one more question in the meantime to Calli, but just so if we get an indication of if folks are asking questions, we'd love to take them. But lastly, Calli, so how, this is maybe the upshot of it, and how do assessments impact potential enforcement actions, right? So I think, from our perspective, at least at EPIC, a lot of times we're wanting these assessments and these instruments as a way to be able to say, hey, this is a problem, we need an enforcement action. So I'm curious to what extent that you've seen that and to what extent you're hoping to see that with more requirements coming into play.
Yeah, so so I did client work previously, but I also have worked a little bit with the Colorado Attorney General's office on some stuff, and I also was at the Federal Trade Commission at different points. And sadly, I think one of the biggest impacts that you see from enforcement and impact assessments is where there's a lack of an impact assessment. The absence is always the most glaring thing. There have been, as I've discussed with enforcement bodies and for brief periods worked with them, there have definitely been impact assessments and audits that seemed like they were insufficient, that seemed like maybe they were incomplete, that seemed like maybe the person or company didn't fully understand what all they needed. And in many of those cases, the enforcement body that I saw could then work with that company as long as there was a foundation to go from. Because you could say, can you provide more information here? This is incomplete. Sometimes there were, penalties or serious discussions that accompanied that. But as long as there was a genuine, at least attempt at an impact assessment or an audit, there was at least somewhere to go from. The circumstances that were always the worst were when you saw the company had just played the gambling game and hoped that they would never get called on that requirement. And that happened much more frequently than I wanted it to.
Yeah, and that also prompted the question on how far enforcer can go. Like, do they really have the capacity and the capability to actually go into your algorithm, et cetera,
Yes.
which certainly on the EU side, when we will have the EU AI Act in force, which we all hope, that will be a very big question. So on how you will actually enforce, and we probably don't want something like we see in many GDPR enforcement cases where basically you have a tick the box question on show me that you have done a DPIAs and then no question on the DPIAs itself. So, but remain to be seen.
One more thought that's truly just personal observation, so I won't say that this is indicative of a much larger trend, although it could be. One thing that I saw with worrying frequency when I was doing the work is that it seemed that the more complex the systems or the more high-risk technical expert level the systems, the more those companies seemed to be willing to make the assumption that the enforcement body would not understand the industry enough to be able to ask follow-up questions. So a lot of those assessments and audits were upsettingly incomplete. And I really do, at least in a few of those cases, it was made clear when we, as the third party that was supposed to be helping them with that, were asking follow-up questions. They clearly knew the answers or knew where to find them, but just had hoped no one would ever ask follow-up questions. So that's another part of enforcement that I hope gets followed up on. I hope enforcers are not so nervous about sounding like they don't know what they're talking about that they just don't follow up.
Yeah, which I guess begs the question whether not publishing about it proactively should be a violation of something in and of itself to make sure that that's being done, because they can't possibly chase it all down. But we'll see. Question?
Yeah, thank you. Does it work? Yeah. My name is Schroeder. I'm from Privacy Company, and I'm super happy to listen to Janneke Gerards. We performed, with the help of her model, the IAMA, human rights impact assessment on the use of Facebook pages by the government. And we also performed a DPIA, a data protection impact assessment. And now government is thinking about a children's right impact assessment. And I'm just wondering our reports take the auditing approach that is recommended by ETICAS and that I completely follow and applaud. And so it's 150 pages DPIA and 100 pages HRIA and then a children's right impact assessment. Is there some way you can help us sort of merge those instruments? What are your visions on that? Thank you.
Charles, I think we were talking a little, yeah, you might have thoughts on that. That overlaps.
Yes, so the difficulty there is if we do paper for paper, it has no meaning. If we produce very valuable papers that are so long that in the end it's still paper for paper, I'm afraid we haven't achieved much neither. So that's why I think it's, at least that's my personal view, that we should be very strategic on when and how we use those tools with a clear idea in mind of what they are supposed to achieve. Because you cannot just pile up things up to a point where no one will read them, and basically you will eventually have shown accountability, but just for yourself, because no one will even give you credit for that, because no one will read it. And that said, if you need to deal with competitive objective, it's hard to merge everything in one document, because you cannot do children privacy, human right, environmental sustainability, protect data privacy in one document. Yeah, then it's a 3,000-page document. My take there is, I'm not sure I'm calling for merging, but probably for a strategic use of those tools, and not to pile them, basically.
Can I say something on it?
Please.
I'd say start with thinking, I don't know where the person who asked the question is. I don't know. Okay. What are you trying to achieve? Are you developing the tech that is aimed at children? Are you an oversight?
We're an audit, basically a privacy consultancy, but we perform these audits for the central Dutch government to help them negotiate better conditions with the cloud providers. So one of the purposes of the staggering amount of detail is not the intention of any individual reading it, but just convince the law department of the recipient big tech provider that it's really thoroughly researched, reproducible, etc. So.
Right. So I'm guessing, like, again, what are you trying to protect? What does the government want you to protect? And maybe we've been working with UNICEF. It's a slow process, but we are working with UNICEF on auditing 15 services targeting children, online 5 in online gaming, 5 in risk assessment in the public sector, and 5 in social media. And the idea is, after the audits, to develop a code of conduct that UNICEF can put forward, saying, if you want to develop technical services targeting children, you need to make sure that you do this, and that. So that model may fit this case, because I'm guessing that the public sector wants to be able to give those recommendations, like the do's and don'ts. And in this case, the audit allows you to get information on what is currently going wrong, what are the good practices, and then put that in these guidelines, recommendations, or code of conduct.
Thanks. You had a question first, and then we got one more. Sorry.
Hi, hello. Thank you to the panelists for all the contributions. My name is Krzysztof. Sorry. Hi, right. Yeah, my name is Krzysztof Garstka. I'm from Trilateral Research, and my question to the panelists is, based on your experiences, which areas, which industries, which sectors are most welcoming to impact assessments and conducting them, supporting them, and which ones are a bit more reluctant to collaborate, conduct? I have some guesses, but I'm really interested in your practical experience here.
Maybe Charles or Gemma, I'm not sure.
So willingly, medical, they're the ones that are more aware of what's at stake. They're heavily regulated. They understand that risk assessment is important. So the ones that are coming to us on their own accord is the medical sector, followed by hiring and social media, because of regulatory developments. So they must. And the ones that are more reluctant, banking. And it's a complex issue because even if they wanted to be audited, they're so heavily regulated by external entities that we're getting to the conclusion that we probably need to work with the regulator of the banking sector in order to ensure that they can manage data sets in ways that are non-discriminatory and compliant. But in any case, we've had conversations with the banking sector where technical people are like, we're very concerned about how we are capturing and reproducing discriminatory practices, and the legal department is like, yes, and we're not going to be the first to blow the whistle on this issue, so this conversation never happened. So banking and the public sector. I gotta say, I am very disappointed at the willingness of the public sector to be scrutinized and to open their systems. In Spain, where I'm from, we've had a law that that makes auditing mandatory for any public system that automates a decision on a Spanish citizen, and no algorithmic systems have been audited in Spain. There's several countries in Europe that have similar regulations. So the non-compliance in the public sector really angers me, because it's very difficult to enforce something that you don't comply with yourself.
Janneke, to that point, did you, to the extent that you can talk about it, are there differences in the types of agencies? I think a lot of times we see the people, the agencies throughout the criminal legal cycle as particularly unwilling to do that, as well as people or agencies that are doling out public benefits, et cetera. The more important stuff are the ones that people don't want to do, in my experience at least. But I'd love if you have any thoughts on.
Yeah, but that's absolutely true. So I was just thinking, indeed. It really depends. I think, well, municipalities are really eager to apply all this. What we can also see, but I think it's really contextual as well. So in the Netherlands, we have had a huge scandal with profiling by the taxation services in relation to fraud. And well, now there seems to be a real openness to improving. Well, people working in the taxation services and social security and social benefits are really willing to think long and to see how they can avoid the same problems from arising again. But what we can also see is indeed all organs involved in prosecution of crime and police are not that eager. And what also strikes me is that immigration services are not very eager on complying. So they value secrecy highly, seemingly. And well, something similar is true for intelligence services, but that probably is not a surprise to anyone either. So yeah, it depends on the policy field on the one hand, but also on, I think, well, recent incidents and matters that have taken place and that have perhaps raised public attention, public scrutiny, which might incentivize certain organs more than others.
Thanks.
As one quick addition, It's not necessarily an industry, but in the US, what I saw the most frequently in was startups. Startups just have no interest in doing assessments or audits because they're so busy trying to like establish themselves and get to this big stage that the idea of spending resources and time or slowing down for even a second to assess what they're building is frequently just not considered.
Yeah, and not finger pointing any sectors. I think the answer is very dependent on the organization, AI, like governance maturity. So when you have organization, whatever the sector, when they already have governance model in place for a long time, they are more than ready to have those impact assessment because they realize it's part of what they should do. For those who are just discovering AI governance, probably they will be less keen.
So we have a few minutes left, so we'll do two. I think there was a gentleman on the aisle that started to come up for the question, so we could take yours first, and then there's also a gentleman at the mic.
Good, thanks. My name is Charles Robb. I'm at University of Edinburgh and the Alan Turing Institute. I've had the chance to look at quite a number of impact assessments, particularly data protection impact assessments that have been done by governmental bodies. And I very much appreciate Janneke's point about how you design the form and the template that's being used, because in my experience, if you ask a question which simply requires somebody to check a box, then that's in a sense useless. You get no information. But if you rephrase the question in terms of not did you do X, but what have you done? How have you done it? Explain it, please, and so on. Then you can drill down in it. But except when it comes to the part which asks, is what you're doing necessary and proportionate, and what are the risks, and how do you evaluate the risks? Because then you get these sort of lovely red, yellow, and green risk matrices, high, low, and whatnot, in which they put arbitrary numbers, and you have no way of knowing whether this is serious or whether somebody is simply throwing a dart at a board, whatever number comes up, you get 180, So how would you, it's very important how you design the template. And I'm trying to make recommendations about how that can be improved. And the second small question is, how do you get over the point that doing an impact assessment is not a once-for-all thing, that you may have to revise it periodically if your purposes change, if your systems change, and so on. So you can't simply do it, put it on a shelf, and let it collect dust. Thank you very much.
Janneke, perhaps, if you have an answer to that.
Yeah, well, we have very consciously and very intentionally not used any kind of green, yellow, and red kind of lights, especially not in relation to those answers related to the fundamental rights risks. Exactly for the reason that you mentioned. So it would reduce the debate to a much too simple kind of question if you would just say, well, this is high risk or low risk. This really is contextually determined. It really depends on the kind of fundamental rights issues that are at stake. It depends on how severely certain fundamental rights are being affected. So especially there, I think it is really necessary for a team to provide some kind of motivation. So what we always say to the people who are actually, involved in and engaged in completing this impact assessment is also, sometimes this really raises very difficult issues that are more ethical than legal or technical in nature. And of course, there is sometimes no real right or wrong answer, but then at least provide for some arguments that in the end, for instance, for political bodies, make it possible to have sufficient information to make an informed choice as to whether or not you would like to use an algorithm of a specific type. And that's, people usually are very much relieved to hear that, and then they really take this seriously and they feel more safe actually in answering these questions, and that opens the floor for deliberation, which I think is extremely important. And then as for the second question, I just briefly, could you please repeat that question?
The sub-question.
Questions about having to do another impact assessment.
How often are they
Change.
updated and required to be updated?
I just wanted to briefly say that we have actually included a question as part of the impact assessment to make a plan for the future use and future development and evaluation of what is actually going on. And that might include when there was, for instance, significant changes in the way the algorithm operates or the way the algorithm interacts with the real data it's being fed, to go through another impact assessment again, and to be willing to actually stop using the algorithm if it turns out that in the end it's more seriously affects fundamental rights than you as a body are willing to accept.
And I know Gemma has one point on this.
Yeah, sorry,
but
very shortly, because document design is crucial to what we do, especially to do it at scale. And so our way, it's not either a yes or a long-winded answer, but when we say, have you performed an impact assessment, if the answer is yes, we ask for the date, for the author, and for a link to the document. The link is not always available, but at least we want the date of the author, so it makes it a lot harder to lie. You're not going to make up the name of someone. So there's middle ground, and now we're developing machine learning to verify that the document that is uploaded actually complies with the requirements of an impact assessment, so that we can even verify further without investing a lot of time. And on the updates, one of the crucial parts of the audit report that we publish at the end of an audit includes the mitigation measures that were not implemented in the auditing process, so that they need to be implemented before we come back. And it also schedules the next time that we come. That next time can be in a year, it can be tomorrow. Like in social media, some checks needs to be performed every single day. So there's no audit report that does not obligate the company to have an update. So, and the idea is that this is recurrent.
And with 1 minute left, I'd love to get this last question and give any answer that we can, at least. And apologies.
Hi, so I'm Ero Balsa. I'm a postdoctoral researcher at Cornell Tech. And my question is actually about objectivity and reproducibility. So I guess that what I'm trying to understand is, like, to the extent that there are like multiple and potentially competing guidelines to perform these assessments, to what extent would you say that if you had a different team taking these guidelines and performing them, they would get to the same result that you did? And to what extent is actually like very much the assessment depends on your own perspective, your own ideology, and to some extent your own politics. So if you could actually comment on that. And then, like, a side note, sure. As a side note is, how does your approach or your own experience like change when you're performing as a first party, second party, and third party, and how that relates to
That's 5 questions.
And anyone have like a 10-second answer to that? Otherwise, perhaps we can connect outside after. But
0% subjectivity. That's our goal. It doesn't matter who does the audit. The result will be the same because the methodology is very much set in stone. We do have at some moments in the process what we call the wild card, when the team gets together and it's like, are we missing something? And then that may vary from team to team, but we are aiming for 0% subjectivity to give that kind of level of certainty to our clients, but also reproducibility of the methodology, regardless of your politics.
Impact assessment, 100% subjectivity.
But one thing, the methodology is political. The methodology itself is political, but it's not about your own politics. It's about the ability to reduce information asymmetries, to open these systems, and to make sure that the systems that are developed with our data to make decisions about us, that we have rights over those systems.
all right, thank you so much to our panelists, and we will get out of your hair.